Just come here, we'll step on the other side of the table. You good with that? Where you sitting? You okay?
Are they bringing him to your table?
To this table. There should be one here somewhere.
Stapler?
A stapler.
You know what, let me give you this one, Jim.
Okay, that'd be good, thank
Yeah.
you. Oh, here, there's one right here.
Okay. Forward. That works better anyway. So when y'all come up here to speak, if you don't want to take your mask off, that's fine, but you need to then project.
Yes, ma'am.
Otherwise, I will lose the little words.
Yes, ma'am.
If you can't hear, please.
So we're gonna ask to see you. Okay. Did you bring it up? Yeah. Did they have it here downstairs? Yeah. I'm just gonna, we're gonna toss it. This. Thank you so much. it's not a normal thing that we would do, but yes, we do this one, yes. Do you want us to go? Yeah, yes, sir.
We're all done?
We're gonna do that. We would be concerned. So we're gonna all go. You want to say this to the same?
This is dead.
It is.
So you need me to bring this to?
Unfortunately.
Well, I have your laptop here. I'm not gonna reach.
Well, that's the live stream.
So it's going here.
Yeah, it's just one straight across.
What is that? Is that a camera?
It's live stream
Live streaming what?
to the YouTube.
Here, do you want to bring it? Yes.
This one probably.
Who's running the live streaming? Is there any way to make sure on your one?
No. That's where it's for.
Okay, so skip one to get started, so then I won't play. I've never used this one, I've used the stuff downstairs.
This is just something where we stole out of eight.
Okay. So right now it's asking for earbuds, what is that?
For who?
Earbuds?
Do external speakers probably.
And how do I,
Well, the judge won't
Oh,
wait
wait,
to
do we
see it.
hey, Skip, how do I make my screen not flash up there right now? Where's the mute button on the remote?
We don't have it, we can do what?
Just open the button, can I do it?
I don't have the remote with this thing anymore. I just shut it off.
Okay.
And we just shut it off. Turn it off like this.
Okay, and then how do I, it's talking about speakers or this?
Oh, that's just shutting the device.
Okay. So where did you turn it off, so I want to make sure,
Oh, you want to do it, it's there.
You need to set something else up?
No.
Oh, this is it? Okay. We don't have to remove
I'm
it.
sending them to go there. Now, this whole room.
Is that how?
The whole thing there.
Oh.
We did get the microphones up. That's what they cut off on the budget.
Okay.
This was a very freaking big, and this one.
Okay.
Now,
So all
we
she
need
has to
the-
do to get this up here is the power button.
Yes.
And then whatever I'm putting into this drive will show up.
It should show exactly, it should mirror exactly what it is.
You wanna test
We'll
the
hang
audio?
it.
You wanna test the audio?
Yeah, but they'll be here.
We'll hang it.
Okay.
I think the question is, where do you want this?
Not on me.
I mean,
Well, I already suggested not on me. He said no.
I don't know where else to put it.
Nice.
I'll do it here. Instead, I get you.
That's all right. I can do it. It's the comment that is so weird.
Do you have that?
All rise. Superior Court of Henry County in session. Marlon Water, security presiding.
May be seated. All right, I have taken my mask off because I know I'm gonna be 6 feet away from most everybody. And I have been fully vaccinated as of February, I will say 14th, that was not the day after, I think, whatever. A couple of announcements that I'd like to make. I understand that we're going to be moving forward today with a little more than I anticipated, but one of which is our arraignment. The defendant has been, this is the second arraignment. Before we begin that, this is one of my first live proceedings. I've done some that were mixed, video and Zoom and such. Essentially, the court reporter is the official reporter. He takes a record of the proceeding. While this is being broadcast for folks who still don't feel comfortable coming to the courthouse in person, that's all right, it's prerogative. You cannot film this proceeding. I can't stop anybody at home from filming it online, I know that. But if it's used inappropriately, there will be ramifications for that. I don't know exactly what, because it's a new world for me. But in the courtroom, everybody that has something like this, which is holding up an Android or Apple phone, can record and video, pictures, but not in the courtroom. This is a place where you have to work your memory, your hearing, your brain, but not your device. No computer recording in this courtroom, no pictures will be taken. If there's a media outlet available that wants to be in here and do that, they're supposed to request under rule number whatever it is. I think it's number 23, I could be wrong. It's been a while since they've never showed up in my courtroom. And you have to get permission. And no one's asked for that. It applies in my world, it applies to people who are sitting here watching a proceeding. The reason for that is there are many ways to record and to re-record and restructure recording so that the proceeding is out of order and things are taken out of context. And then when you start having to explain why something's not accurate, then you're already lost half the fight. So I don't like for anybody to record anything, and the specific rule in the court that you're not to use those devices in this courtroom today to record any part of this proceeding. If you do, and you're caught, you may lose your device for a certain period of time. I don't know, there are judges that take them away from everybody. I don't like that. I like to assume that people will listen to judges until proven otherwise. And then if your device is taken from you, it may be some time of, and I think the worst criminal punishment I have available to me is 20 days for contempt, which is the first day I can take it from for 20 days, I suppose. You might not be happy about that. I don't want to do that. The other options are jail and fines, neither one of which we all want to do. I just want to have a nice, simple proceeding where we adjudicate the rights and the justice is prevailing, and that no one is prejudiced by what's going on some other side of anybody that's present. If there's anyone present here in person who would rather do it online and watch this online, you're more than welcome. I've got the link if you don't have it, and I can send it to your cell phone or to your email address, I think. You just have to let us know. You can leave, and I can send it to you. And we're planning on being here tomorrow, which we do believe we're going to tomorrow. It'll be broadcast again. I'm sure we can do the same link. If not, we'll have a new one. But that can be done. As long as we're here, I expect you to behave and pay attention. Some people can't hear. Where's the microphone? Let's see if this is so long since I've been in here. Is that better? Can you hear me now? Now, this is the humor. What part of what I said did you not hear? Nobody knows that. There's no answer to that question. I don't want anybody recording anything that's going on in this courtroom other than the court report. That's their job. Don't take pictures, don't take videos. Use your brain, your eyes, your ears, all senses that you have. Pay attention to what's going on. If you'd rather be online, you can go online. There's a link to this proceeding and tomorrow also. And we can get that to you. You just have to let someone know what your email address is so we can send that link. The doing this afternoon, we're gonna be doing motions, but now we have a new indictment on the stand. So, we'll have to deal with that new indictment, which is number 2021 SU-CR 63. My understanding.
It's 6:30, Your Honor.
Oh, 663?
630.
Oh, 630, all right. I asked if there was an initial AM after, and they didn't know. I don't know.
For some reason, Your Honor, they put HB for Judge Neal, but obviously,
Right,
we're gonna ask you to incorporate
the
it.
case. I'm gonna have to get the assignment orders redone, just to be on the safe side. Thank you. And who is going to be announcing on behalf of the Mr. Baker at the arraignment?
Judge.
Mr. Court, before you have a notification for everybody? Okay.
Thank you.
Aye.
Good afternoon again, Your Honor. Shayla Galloway on behalf of Mr. Baker. With respect to the arraignment and the new indictment, I think at the outset I need to tell the court that we haven't even been furnished a copy of the new indictment, which means that Mr. Baker hasn't been furnished a copy. We'd like to address it further before there's any presentment to the court for its consideration as it relates to the new indictment and sole purpose that we were coming into court for today. Ms. Rudy will handle that, but I just wanted to let the court know that as of 1:59, we don't even have copies of whatever the state is intending to do.
And Your Honor, Debbie Cano, on behalf of the state, we have a copy from them right here. My understanding is that notices for arraignment went out. The clerk's office told us that they were sending notices out. So we were informed that the defense would be notified that there was a new case number today we would be doing arraignment. And so I have a copy, usually at arraignment, you turn over a copy to the defense, so I have a copy right here.
Well, along with the defense, I found out about it today also.
Oh, I'm sorry, Your Honor.
That's the first I
Didn't know you didn't know that.
today. It's hard to imagine. I tell you what, I think may work, since there is a motion, I think, has y'all been filed, have y'all seen the state's motion to incorporate all previous filings of motion, discovery rules, and motions associated with the case?
No, Judge, we have not been provided with that motion.
Okay.
We've received nothing from the state, Your Honor.
Okay.
And Your Honor, I have those with me today. We just filed those today. Knowing that we were reviewing that. Mr. Patillo signed those and they were filed earlier today. So I have copies
Let's
of
do
everything.
this, and let me make a suggestion. Why not move forward with what we're here for originally? Has the old indictment been dismissed yet?
No, Your Honor.
We can still proceed under the old indictment. If the state's motion is good, without ruling under the old indictment, to the new indictment, at the point in time when it's arraigned, we can do that, and our rulings today will still be applicable to the new case.
I'd like to address that point at the appropriate time, Your Honor. If now's the appropriate time.
But almost, I just wanted to also, if I didn't make this announcement, if you have a cell phone and you like to not interrupt court proceedings, you can put it on mute. That's what I have tried to do, and my wife has taught me how to put it on temporary, so that I don't forget for days, and I wonder why I didn't have any calls. You can put it on mute, that way we won't have any interruptions in the proceedings. Is the defense objecting to proceeding under the arraignment of a new indictment?
Your Honor, as far as, so I guess this is the situation. Under the new, there have been actually two new indictments. One was filed on June 20th, one was filed on, May 20th, one was filed on June 9th, Your Honor. As Ms. Galloway has mentioned, we have not received a copy by email, and no notice of what the new indictment was. We haven't received anything from the state. We haven't received the motion. So, Judge, there's also not been a notice of intent to seek the death penalty filed under those two new indictments. And so, as the court's aware, the incident in this case occurred on October 27th, 2016. The first indictment came down on January 24th of 2017, and it was shortly after that that Ms. Galloway and I filed our entries of appearance in this case. We filed our motions in this case in, I believe that it was, we filed our very first motions in June of 2017, and we filed our full array of motions in August of 2017. There was no court order in place, we were ready, we were prepared, we filed those motions. The state's responses were filed on December 4th, I believe, of 2019, over 2 years after we had filed our motions. So for 4.5 years, Your Honor, we've been proceeding under the 2017 indictment. That 2017 indictment has a total of 19 counts in it, and they are malice murder, felony murder, aggravated assault, possession of a firearm, though those counts don't apply to Mr. Baker, but possession of a firearm during the commission of a felony, that those counts did apply to Mr. Baker. So 19 counts on the indictment, co-defendant on that indictment, and not all of those counts applied to Mr. Baker. The new indictments that we have not been, the state has not provided us copies with, now have 30 counts. And those 30 counts now include a significant additional number of counts of felony murder. It now includes, which is not in the original indictment, 2 counts of burglary in the first degree. It now includes 4 counts of criminal attempted to commit felony, that attempted felony being attempted armed robbery, and then again the possession of a firearm during the commission of felony. So this is a massive expansion of the indictment. It changes the landscape of the case. It changes the charges that we need to defend against. It changes our theory of defense. And the state filed it 4.5 years after the incident, after we had filed our motions, after we had heard arguments on our motions, after Mr. Koski stood up in court and pled guilty to being the one that shot the 4 individuals in this case and received a life sentence without the possibility of parole. He pled under the old indictment, the 2017 indictment. So today, with no notice, we're now with these 2 new indictments. And Your Honor, what I will clarify though is the June 9th and the, okay, yes, thank you, Ms. Galloway. The May 20th and June 9th indictments, in terms of the substantively, they are, like the counts are the same, the allegations are the same. It appears, just by trying to read the tea leaves here, that the reason why the second one was filed was because they had forgotten to include the many judicial orders that were in place, which even allow them to re-indict 4.5 years after the incident, because the statute of limitations is typically 4 years, and they waited past those 4 years and are now at the waning days of the judicial emergency, now re-indicting Mr. Baker. So where we stand from a technical perspective, Your Honor, from a procedural perspective, is that we've got 3 indictments that are all live indictments, that are all valid, no null process or motions to dismiss those have been filed on those. So they're all valid indictments that are now in the clerk's file. We have only filed entries of appearance, and we have only had first proceeding and arraignment in the 2017 indictment. And I cannot emphasize enough, Your Honor, that the charges, the allegations, the counts in the 2017 indictment are so significantly different from what is in the 2021 indictments that it is incumbent upon us to, 1, take a look at these new indictments to figure out whether or not we have challenges to them in the first place, and 2, to evaluate how those new indictments change what we file, the arguments that we make on those motions, the investigation that we do, and the conversations that we have with our client. Now, this first indictment, Judge, so on the 2021 indictments, we would not be prepared to go forward on those because we have received notice today, essentially, from the state on those motions today. We, through basically serendipity, found out about them just a few days ago. Since May 20th, when the first re-indictment came down, that is time that Ms. Galloway, Mr. Studelskin, and I could have been taking a look at the case, the discovery, the motions, the record, to make an assessment as to whether or not we can adopt the record and go forward. But we have not had that opportunity because we hadn't been provided with sufficient notice. So there were 38 days where we could have been doing that work and we could have been prepared to go forward. But as we stand now, if we're only under the 2017 indictment, we have filed motions, we would be prepared to go forward under that. But if they're going to null process that indictment, then it seems pointless to have hearings on that indictment if it's going to be null processed. And if we're going to go forward under the new indictments, I can't say whether or not my arguments, my questions, my motions are going to be the same because of the massive change in the indictment. So we would oppose adopting the record from the 2017 indictment into the new 2021 indictments, because we simply haven't had an opportunity to make an assessment as to whether or not that's something that we ought to be doing. And so let me just make sure that I've covered everything, Your Honor. And what I will note, Judge, is we have been in constant communication with the court, with the state, concerning these hearings, and there was ample opportunity for us to be notified, for us to be just given a heads up so that we could take the appropriate actions to be prepared to go forward today. I have 3 witnesses subpoenaed, Your Honor, they're here. But without notice, without us being told what these changes were, we have been deprived of an opportunity to be prepared. Judge, so we would be asking that we reset these motions for a later date. Today, I think that we would be prepared to go forward on a first proceeding in arraignment. Would that be correct, Ms. Galloway? Yes. And then we would ask for some time, it does not need to be a significant amount of time, but time for us to sit down, review the discovery, review the record that we're being asked to adopt, because the discovery is voluminous, the record is voluminous, and make assessments as to what we would adopt, what we wouldn't adopt, and to refile anything that we would need to refile with these new charges in mind. And the last thing that I will say, judges, in capital work, we get reindictments all the time. We get them in most of our cases. However, Judge, and we often adopt the record. And so that's our usual take on this. But Judge, the substance of the case, they don't change the charges that we have to defend against. They don't cause us to have to rethink our theory of the case. Or there are cases in which are reindictments that are meant to take advantage of new jury selection procedures. Those are all things that they don't change our need to, our motions, and we have no problems adopting the record in those types of cases. But when we go from 19 counts to 30 counts, we've got charges of burglary and attempted armed robbery that we're just dealing with or just finding out about today. We need an opportunity to make sure that what we are filing actually reflects the indictment in this case, which is, as the court knows, the foundation of this case. That tells the jurors what they're to be considering as far as charges go, and it determines the possible sentencing that Mr. Baker would be subject to. So we would just be asking, Your Honor, for an opportunity to be able to review these new indictments, file any demurs to the indictments, and to make an assessment as to what needs to be refiled, what needs to be refiled, or adopt what needs to be adopted, and then we would be prepared to go forward after we've been able to make those adjustments. Thank you, Judge.
Good afternoon, Your Honor. Your Honor, the 2017 SUCR 73 AM, that is the old indictment, as you're aware. The new indictment that was filed on May 20th, it was not re-indicted because we didn't include the many judicial orders we did. I made copies of them myself and attached them. That's not the reason. The reason is that count 1 in that indictment, for whatever reason, the system, when it pulled it, it's a malice murder count. Count 1 should have been OCGA 1651. Instead, it says malice murder, but it pulled the code section for false statements, which is 161020. And we didn't catch that because that is not something that our system ever does. I've been using Tracker, the system that we use for years, for the better part of the last decade, and I've never seen it do that. And it automatically populates things like the date, the name, the code section, the charge. And for whatever reason, on count one, it messed it up. And so that's why we went back and re-indicted it on June 9th. And the new indictment is 2021 SUCR 630 HB. And Your Honor, the defense did have notice that we were re-indicting it. I know Mr. Patillo spoke to Ms. Galloway, telling her that we would be re-indicting the case. I know that they received notice from the clerk's office on June 15th, 2021, that there was a new case number. I'm looking at the clerk's website, and it says criminal arraignment and non-jury calendar notice, and it has all the counts on there, and it has the date on there, and it has to Christina P. Rudy. It has another one to Ms. Galloway. So they did get notice that today was an arraignment date as well, because I spoke to Ms. Holland from the clerk's office asking, did we want them to send notice? And we said, yes, we would like to. If we can, we would go ahead and ask that arraignment be, since we're all going to be here, let's do it on that day. With regards to the motions for today, so yes, we did add additional counts. However, the motions for today are things like motions to suppress his statement that he made to the detective. The new indictment doesn't change what his statement is. It's either admissible or it's not admissible. It's the same statement, whether it's a 2017 case number or it's a 2021 indictment number. With regards to his other motions that we're doing this week, motion to suppress the search warrants for his home and for his DNA. The style of the case itself and the charges don't change whether or not those search warrants are valid and should be allowed into court. Similarly, with the motion to suppress the arrest warrants, those arrest warrants were issued back right after this all happened, back in 2016. And so, again, whether we're operating under 2017 SUCR 73 or 2021 SUCR 630, it doesn't change those things early on. And I actually do have copies. I have a copy of the indictment with all of the Supreme Court orders attached to it. I have a copy of the notice of the state's intent to seek the death penalty, and these are all under 2021 SUCR 630 HB, and that was filed today. And I have the state's motion to incorporate all previous filings from the 2017 case into this case number. And for the record, I'm going to serve it on the defense today, because typically an arraignment is when you serve these things on the defense. But they were aware. I've spoken to Mr. Patillo, and he's indicated that he did let the defense know that we would be re-indicting the case. So I just wanted to let the court know that. In addition to that, they did receive notice of arraignment. But the biggest argument, Your Honor, is they want to take a look at everything. It doesn't impact the motions that we're doing this week. Those motions don't change. The arrest warrant doesn't change based on the case number and the charges. The motion to suppress his statements don't change based on the case number and the charges. And the motion to suppress the search warrants for his home and his DNA don't change just because the case number and the charges have changed. Those are all still the same. They may file additional motions based on this new indictment, but that's not what we're here for this week. So nothing about re-indicting the case and filing a new death notice and asking to incorporate it, and nothing about that should impede our ability to do these three motions that are scheduled for this week.
All right, anything last word?
Yes, Your Honor, I just want to speak to something just only because my name was brought into it. I'll let Ms. Rudy continue it as it relates to the argument and why we are opposing the adoption of what's happened prior to this case under the old indictment. Judge, I've talked extensively, mainly to Mr. Patillo, because he and I pretty much, our careers have tracked at the same rate. He has my personal email and cell. I have never, and I will say this clearly on the record, have never had a discussion with him as it relates to a re-indictment in this case. That is not something that I would forget. In 17 years of practice, I would not forget that. I have spoken to him as recently as 3 weeks ago about other matters that have happened in this case, because as a professional courtesy, I wanted him to know where we stood on some things. That's what I've always done. When he and I were both in the cab, when Ms. Benuto and I were in the cab, there has never been a time where I've never extended that. So yes, you can file something today and give it to me today, but I've never operated that way. This is about life and death, so I don't play games as it relates to capital cases. I just don't. I don't have the time to do that. And so what I've always done, and I will continue to do, is when new things happen, I will apprise the state, not the day of, not the day before. I was not extended that professional courtesy by any of them. And so I just want to make it clear that this is not in any way an attempt to delay anything, as Ms. Ruby just announced. We're ready because we have witnesses here. But even at our own inconvenience of being ready, what we cannot do, and what we should not do, is make sure that we impede or infringe on what we should be doing for Mr. Baker as it relates to what we're supposed to do as outlined by the UAP. Today, as it relates to arraignment and the first proceeding, all of this that we have not reviewed with him, from the 19 counts to the 30 counts, of course the question that anybody would ask is, how did it get that way? I can't tell him that in the few minutes that I have known about this re-indictment. So I just wanted the court to know, I know a lot goes on as it relates to lawyers, but I just think it's important for me to convey to you that that's not what happened here. We did not know, Judge. And the only way that we did know a few days ago is just doing our own online research, because we spoke to Mr. Baker and he just said, hey, I think I have more charges. And I said, and I don't know anything about that, so I can't even discuss that with him. So I just wanted to bring that to the court's attention, since and certainly, obviously we can hear from Mr. Tiller, but as it relates to me and the information that I received, I haven't received that.
I'll just, I just have a few brief points to make with regards to Ms. Venuto's argument. Judge, it's not Ms. Venuto's place to tell us what our arguments are, or whether they're going to change based off of the indictment, or whether or not we should adopt previous filings. That is our decision, based off of our discussions and our review and our understanding of what our theory of defense is. Just because Ms. Venuto doesn't see or think that the arguments are going to change, that doesn't change that it is our decision. And even if, Judge, the fact of the matter is that there is, under the 2021 indictments, there are no motions filed for us to go forward under. And you can't, not you, Judge, we cannot be forced to adopt records and adopt filings that we're not agreeing to. It is our responsibility to decide what we file and what arguments we make. And for the state to tell us what those arguments ought to be or that they shouldn't change infringes upon our obligations to Mr. Baker. Judge, as I said, I don't think that we need a tremendous amount of time, but we need an opportunity. We need a chance to take a look at this and either refile what needs to be refiled, or we need to adopt what we need to adopt. But as Ms. Galloway said, this is a matter of life and death for Mr. Baker, and we all take it very seriously, and we don't do things last minute. And Judge, this is not the type of professional level of preparation that is. So whenever we, I'll phrase it this way, Judge, whenever we state our qualifications on the record as part of the unified appeal, as first chair, we would state that we are aware of the level of professional performance that we are to be held to in a capital case. And we cannot do that. We cannot uphold our obligations, our ethical obligations, if we don't at least have a chance to sit down, look at the indictment, look at the discovery, and reassess what needs to be done. And so, Judge, we would be asking again for us to do the first proceeding, an arraignment, and to set this down for some time in the future so that we would be able to proceed on the Jackson Ditto and the motions to suppress. Thank you, Judge.
Okay. Well, not here at the record, but the defense is not objecting to the first proceeding and the arraignment.
Your Honor,
I mean,
Let's deal with, we've had enough, we're already an hour in our time almost.
No, we aren't.
And we haven't even got, well, 1:30 was the scheduled begin time. We haven't ended but an hour into actual court time. But that's still time that's going by that we can't recapture. Essentially, there's no harm that I can see if you come to the defendant from hearing an idea for the day and treating it as the first appearance. I mean, it's just like starting from scratch. Now, I would have a difficult time arguing against the motion to incorporate, but I think because of the expansion, just even if it were just one extra count, it would be sufficient to put off the motions that I'm pretty sure are going to be adopted at some point. I don't know. But to do the arraignment is not a problem. And we're not going to do no particular order. We can do the first appearance, which we've already done on the previous indictment, which almost says, well, you're not going to adopt the proceeding, the previous proceeding, because the first appearance. But this is a different indictment. It has not expanded the facts. The facts are what they are. Whatever they are proven at some point, they are the facts that they are. Whether they constitute the extra charges or not is an issue for a jury to make a determination. He was not at risk facing extra charges if it went forward to a trial when it was 19 or 17, I mean, counts versus 30. But he is at risk, even, you might call it not as important because there is a death penalty only on certain charges. That is the ultimate punishment. But essentially, I think in the scheme of things, we know not everything at the end shakes out the way we think they do at jury trial and as an appellate procedure. You may very well end up, and can end up, with a totally different ballgame on an appeal where half the indictment for charges are got away with. And so then those not so important charges might be very important at that juncture because it may be something else. So essentially, I would like to move forward with the arraignment. They're not guilty plea put on today. Let's do the first appearance. I've got my book here. I'll walk through the first appearance. It's not any different than what we did before, since we've got different charges. And then I'm going to put a question to the defense. Nobody's mentioned, it's really, you got close to it. You couldn't say, and you didn't have to say at that juncture, but you're going to have to sometime today tell me how much time do you think you will need before we can come back and discuss all of the other motions that have previously been heard. I'm not going to ask you to want to give me a timeline of what new motion this might involve, because that takes more time. But if you can give me a timeline, if you have one, I'll take it now.
I think we just need a few moments to talk, but I think that we can give you a timeline for when we would be able to be back on the Jackson Deno. I think we can give you a timeline on that today, Judge. We just probably need a moment to discuss it, but I don't see any reason, I don't want to speak for, but we can give the court an idea of when we would be able to
While
be back.
you're doing that discussion, why don't we do this? Mr. Baker has clothes that he can be dressed out in. With what our discussion previously was about outside in chambers. And I will talk to the staff outside the presence of everybody, not just in this case, but all the cases where there's that address that issue that I'm involved in. I don't see the harm in going forward today, like, we wouldn't be out here, Mr. Baker wouldn't be in the Johnson. But that's in this particular case, and I like any time a family, any friends, or whoever has clothing provided for a defendant, they should be dressed in. That was provided for a reason. Now, it may not be that there's a whole lot of harm for them not to be dressed out, but it's better not to take that chance. He's got the clothes, there's no delay. So what we're going to do, we're going to take a 15, maybe 20 minutes more likely. I think we'll give you more time to make some calls. And I want to give 20 minutes. Mr. Baker needs to be dressed out at the first part of the break, so that if they have things they need to talk to Mr. Baker about after he's dressed out, they will have a little extra time to talk to him after they have these discussions. So we'll take a break until 10 till 3. That's a little over 23 minutes. Mr. Patello, welcome to the game.
Thank you, Judge. If I could just make a point of clarification with respect to the court's ruling and direction, I do want to point out that Ms. Galloway and I have had extensive conversations about this case. including everything from scheduling to trying to work out the case short of a trial. And in those conversations, we made an offer to Mr. Baker through his counsel after consultation with the 4 families in this case. And in some of those conversations, I did talk to Ms. Galloway about if he did not accept that offer, that the case would be re-indicted. We talked about this extensively during the pandemic. As the court knows, a lot was going on. But we have had conversations about that, specifically that the case would be re-indicted and that charges would be added. And I even went into the specifics of the nature of the charges that would be added. That may not affect the court's rulings today, Judge. I just wanted to make that point of clarification for the court and for all the people observing the trial, the hearings today.
I don't think that they were necessarily objecting to the indictment as much as not having been provided a copy of it before today.
Well, it was stated, Judge, that I had never communicated that at all to the defense, and that's just not true.
Well, they were communicating that if they didn't accept that you would reunite. It's also different from actually reuniting, because the grand jury judge, well, not recently, that wasn't that long ago, you started having grand jury sessions again, and you have a lot in front of it, I'm sure, that had to be done. But essentially, we're going to go ahead. Down in 20 minutes, and Mr. Baker will be dressed out, and then we'll get the arraignment done in the first appearance, and then we'll talk about the other things. Right?
Your Honor, can we use this room over here?
Sure.
Thank you, Judge.
Your room will be here. You're going up, that's going down.
Maybe this is probably the best event to go off the side where they will allow us to overshare. Can we go out the side over here as well? Or Baker?
No, Baker, Mr. Baker is downstairs. He is that right there.
Well, that's good. It's okay.
That's
great. Oh, we can go over here.
Okay.
Give me a chance.
You going back in the chamber, sir?
I am. Thank you. Read my little book. I think we have one thing.
If everybody gets out, I'll sit here.
This is the one that we're talking about. See, reunited with 17 was reunited to this, and then this one was reunited to this. Nobody can tell me put a place and stuff. Leaving it that's the same.
When we come back, we need to be agreed to the first agreement.
Go ahead.
This new, under this new case now. Yes, that's the this one. And then, and get a good, like that, be clear. And then it'll be like that, and then this person right here, I guess they can still do, not with the free on the maybe. Maybe. Yeah, maybe. So basically, we'll come back, we'll do the first appearance on this new case number. And then he'll ask them how much time they think they need, and if it includes that person.
This one, this is all the same. This is, I always have to use this.
Yep.
Yep. And this is the new one. Yep. And then we got to put a copy of this one in each one. And so we got to put 8 in. I don't know what it told me, but 8 in.
let's just call it Bill or Gary, so that's not.
Go ahead.
Yeah, so,
So that will not, like, hold up in the future, like next time we come here, if they say, well, it's been changed now from 8 p.m. to AM,
oh, yeah,
we're holding it in. So, we'll just have to see what they decide to do and how they decide to argue it. And then we'll go from that. My God, it's kind of cool. Well, how do I do it? I'm here no matter what happens, so go for it. Go for it.
Yes, sir. I will do that right now, sir. Yeah, I'll fill you in on it over.
Yeah, it's no big deal. I understood you locked that because everybody did it, right? I think you probably let me back in before you started up again.
No, kind of playing an important role.
Is Skip the one that is running this,
IT,
yeah,
he was up here with two other.
Can you reach him in some way? And the reason that I'm wondering is, I don't really care if I'm on that camera or not,
Mhm.
but I don't want the record on the camera. And if it's picking up what I'm putting down on my computer, that can't be because it's not, you know, what I'm talking about. It's, yeah. I tilted my screen down. I just want you to check YouTube and make sure that no one can read my screen.
Do you want to call him? Or,
I don't know if they'll answer my unknown number.
I think it depends on where he's in a building, whether to pick up
Yeah.
his cell phone or call him his office.
This is the little old one. Okay, well, I'll do my best to protect the screen, but if you do happen to get him or talk to him, then we can talk.
Send him a text.
Okay. Just trying to get in touch with Skip, because this is running out on YouTube and live. And the way it's pointed, I've been trying to protect the screen so that it doesn't pick up what I'm putting down, because that's not allowed to go out.
Right,
So we're trying to get in touch with him to see. I think I've blocked the screen well enough
Yeah.
so far.
Good call. Yeah,
But,
whatever we need to do to help with
yeah.
that. Good call, good call.
Someone standing in front of the camera.
Yeah, we can do that.
He's getting dressed up.
He is, okay, perfect, thank you.
I really don't care. I was joking with him earlier about, don't put me on there, but I don't really care if I'm on there or not. I just don't
I
want,
sent him a message.
yeah, I just don't want the screen to be on there.
I did inform him and, my coworkers that you were on to speak with him for the judge to stand, so, and I told Baker that quicker he gets changed out, quicker we can bring him up here.
Yeah. Okay, I appreciate that, thank you so much.
Next question, sir. The, earphones that you have, do they work? Do they sound good?
I have only had them for about a week. I have two other coworkers that swear by them.
Yeah, I've never seen somebody actually, using them, because I have hearing loss, and so, but the bone conductor one, it should work for me, so I was.
It does, it works good, and then if you're having issues, you put your hands up like that, and it amplifies the alarm.
You want my card?
Thank you for that.
All this information from.
Look at the information I have and tell me if it's correct.
Earphones don't work. I mean, they do on the one side.
Right.
If.
No, I do.
Okay.
So this may all be wrong.
They're gonna be bringing them up, so let's. Move chairs around.
Well. Right now, it's probably best to go out there.
Right, that's right.
Let y'all.
Right. Oh, they just tell me to
I informed them, they wanted to see.
Yes, please, thank you.
I was like, you made it.
Yes.
Oh, okay.
Skip says he can't read it.
334, that's still the same phone number?
Yeah.
Okay, all right.
So Christina.
Yeah. With no.
No, just look at it on the
Okay,
But I'll give you that. That's my cell phone.
okay, all right. She's gonna be made here.
Just the best way to get a copy of the
We'll just send it to you. I do all, I transcribe all of these. So, and I'm not really backed up right now, so I'll go to work on it right away. And I'll give you as soon as it's done. So, yeah.
Thank you so much.
Okay, so I'll just make sure. And copy both sides.
Except for right outside the.
We're fine with like we can like email electronic copy, whatever.
Copy, okay.
Your email is that's the alphabet.
Okay, I mean, we were just changing the information, the address and all that kind of stuff.
Yep,
Yes.
Don't worry, I just.
Okay.
And if I send struggle, as long as it's still in the air.
Okay, we're ready to go.
Okay.
Okay.
Thank you.
Well, no, she's saying for future reference. No,
Well, it's just a great thing, I don't want. I'll block it, but I don't know. If they go back to us and think that more towards the state, that will eliminate the problem altogether. Yeah, there goes that. We'll just check that nothing's gone out.
As far as.
And, I'll be sending y'all the picture today. I will get and start working with that because so they didn't actually. So you'll be getting that. Okay, we'll send it out. Regular. Okay, thank you so much.
Did I tell you, skip the city, he couldn't read?
Perfect. Okay. Thank you. Okay.
Remain seated for.
All right, y'all ready to do it?
This is ready.
All right.
Judge, if I may, I think according to the UAP, we should do the first proceeding where we put our qualifications on the record first, and then we will be prepared to move forward with the arraignment. I think that's correct.
Yes.
Well, that's why they call it the first proceeding. Because it's first.
Yes, sir.
That is right, Judge.
Now, I think what I will adopt is y'all's qualifications. I don't think they have to be restated now. We sort of have a different defense team. From the beginning, we have an addition, I guess, if you say it that way.
Yes, sir.
At the earliest possible opportunity, after indictment before arraignment, the court shall confer with the prosecuting attorney and defense counsel, the defendant shall be present. Mr. Baker is here, defense attorneys are here, prosecutors are here. This is going to be on the record and transcribed. The state has already indicated it's correct that they're going to be seeking the death penalty.
Yes, Your Honor.
That better change your part, okay.
So no, the state's filed, under the new indictment, which is, 2021 SUCR 630 HB. We filed the state's notice to seek the death penalty today.
I don't suspect, that the Supreme Court knows that this is a re-indictment, but we'll send them a copy of the new one anyway. You'll have to do that within 10 days. Defense counsel, y'all want to go ahead and make your identification on the record, it's the same as before, except we have one additional attorney, so why don't we do that? The mayor changed that, I kept a record, I mean.
Judge, I think it may just be easier if we all just go ahead.
That'll be fine. Why don't y'all go ahead, y'all, in any order y'all choose.
Thank you, Judge. I'll go first. As outlined by the Unified Appeal Procedure, also known as the UAP. As lead counsel, I am a member in good standing of the State Bar of Georgia. I have been practicing criminal litigation since 2004 as a criminal defense attorney. I have been lead counsel, or I've been co-counsel on not only death penalty cases, but murder cases, which have gone from trial to verdict. I am familiar with the Unified Appeal Procedure. I am familiar with and experiencing the utilization of expert witnesses and evidence, including but not limited to psychiatric and forensic evidence. And I have attended within the last 12 months at least 10 hours of specialized training or educational programs in death penalty defense. Lastly, I have demonstrated the necessary proficiency and commitment that exemplifies the quality of representation appropriate to capital cases. My name is Shayla Galloway, and I am the lead counsel for Matthew Baker.
My name is Nathaniel Sabilska, and I will be co-counsel in this case. I am a member in good standing of the State Bar of Georgia. I have at least 3 years of criminal trial experience as a criminal defense attorney. I have been lead or co-counsel in at least one non-death penalty murder trial verdict, and in at least 2 felony jury trials. And in the last 12 months, I have attended and obtained at least 10 hours of specialized training in death penalty defense, and will continue to get such training during the pendency of this case.
Your Honor, my name is Christina Reed. I'll be serving as co-counsel for Mr. Baker. I am a member in good standing of the state bar with at least 3 years of criminal trial experience as a defense attorney. I have been lead or co-counsel in at least one non-death penalty murder trial and verdict, and in at least 2 felony jury trials. And during the last 12 months, I have attended at least 10 hours of specialized training in death penalty defense, and I will continue to maintain that training during the pendency of this case.
All right. Is there any need to give y'all additional copies of the unified appeal procedure, or the copies you have sufficient?
No need for additional copies, Your Honor. The copies we have are sufficient.
All
And
right.
I think for the record, I also gave a copy to the defense
All
today.
right, and anybody that also wants to get a copy, they can go to www.ga, Georgia Supreme Court, GAUSUPREME.us, and obtain copies there. All right, now, I'm also supposed to inform everyone that's involved, defense counsel and prosecutor, that here's the instructions on the unified procedure. Court reporter, you should have one previously given to you, copy. You have a copy of the unified appeal procedure?
Yes, okay.
That's the same, you don't need to know. All right, thank you. Defense counsel shall be instructed that the outline checklists are intended to assist them in protecting the defendant's rights, but it remains the responsibility of defense counsel to protect those rights. The outline checklist will not take the place of the counsel actively representing the defendant. Y'all understand?
Yes, Judge,
The
we do.
guide for y'all, and assistant is a very able one, but you also have got lots of good training. All right, defense counsel shall be reminded of the defendant's opportunity to invoke the provisions of the Georgia Criminal Procedure Discovery Act, OCGA 1716-1, TSMQ. I believe y'all have elected to participate in reciprocal discovery, if I'm not mistaken, previously. You not hear me? Thank you, Joseph. All right. The defense counsel is informed that the defendant have an option to invoke the provisions of the Georgia Criminal Procedure Discovery Act, OCGA section 17-16-1. If the defendant elects to participate in reciprocal discovery, both parties shall be reminded that the information provided shall be accurate and complete. Y'all understand that as defense lawyers?
Yes, Judge.
And I'm assuming the prosecutor understands it's supposed to be accurate and complete also.
Yes, Your Honor.
I will mention this, I don't know where we are, the court's supposed to determine whether the defendant intends to present a challenge to the composition. I thought I read somewhere they don't do that anymore.
Yes, Judge, we do, we do still raise challenges to the jury composition. We just don't do it under the force balancing anymore, Judge, but we do challenge it under the jury composition rule, and we will be filing and litigating a challenge of that nature in Mr. Baker's case, both with regards to the grand and traverse jury, Judge.
All right. I was reading the next paragraph somewhere, I read that yesterday, I guess. The county's use of a county master jury list procedure pursuant to the jury composition rule shall establish a prima facie case that the list represents a fair cross-section of the community. This provision shall not be construed to deprive the defendant of any rights under the Constitution of the United States or the Constitution, right? This notification of establishing prima facie rights. And it represents a cross-section of the community. All right. The court shall give the defendant an opportunity, and this, I know pretty much what happens here, Mr. Baker. I get to give you an opportunity to state objections to the defense counsel to the manner in which the defense counsel is conducted or conducted the defense. And at the conclusion of this proceeding, we'll ask you about that. So you need to provide the answer that I'm sure they've already told you that you need to provide, but you'll provide whatever answer you provide. I'm not trying to tell you which way or the other, but I will ask you specifically about that at the end of this proceeding, okay? The court shall review part 1 of the checklist with defense counsel and prosecutor to determine which pretrial issue the defendant intends to raise. I'm assuming it's a good evidence of that. At least what has been raised already in the previous indictment would be good evidence of what you intend to raise, and that there might be others that arise out of the additional charges that have been formulated in the indictment. So we might have to cover that at a later point. Hearing shall be scheduled for any issue the defense wishes to present. We'll talk about that in a minute. I don't even know why they say this, and while the defendant shall be reminded that the issue not taken have been waived if not timely presented. There are still some that are waived, but there are fewer and far between because of the fact that we don't have any ineffective assistance of counsel to cause a problem. The defense counsel instructed that they are located and interview all persons whose testimony might be helpful in discovery and supported by the theories of defense or litigation of punishment. And the court shall schedule an appropriate time for arraignment, which is in a minute, and plea on the merits of the indictment. I believe that is the beginning of the preliminary decision. We will schedule a motion here at some point, I'm not sure when, but right now it's probably a good time. Mr. Baker, up until this arraignment which is about to take place, have you have an opinion as to whether or not your defense counsel has rendered effective assistance to this juncture or not? Do you have an opinion?
On the advice of counsel, I decline to answer any questions.
Thank you very much. Okay, well now would be a good time for arraignment. I think that concludes the preliminary pre-arraignment information. So y'all ready to enter a not guilty plea? Baker?
Yes, Judge, we would be waiving formal reading of the indictment and pleading not guilty, and we would be prepared to sign the indictment.
All right. The original up here, I think.
Oh, okay.
Get in this file.